Chapter 19 is about the disciplinary process. And I'm just going to go ahead and tell you up front, this is the most tested section in the entire textbook. So I'm going to recommend that you know this entire section, cover to cover, because you're going to get most of your questions from right here. Let's start out with the disciplinary procedures part of it. Remember that we are governed through Florida Statute 475, which is the real estate license law, and also Florida Statute 455, which is the DBPR, the Department of Business and Professional Regulations, as a professional. And there are a number of things that you're going to absolutely have to know about. When we're dealing with discipline, the Florida Real Estate Commission only has the right to discipline licensees. Individuals that are unlicensed, the state attorney can discipline. To begin with, there is a complaint process that I want to go over with you that's going to be important, and I'm just going to hit the highlights of it right now, and then I'm going to go in detail with all this. We're going to talk about complaints, investigations, probable cause, formal complaints, the hearing process, the final order, and the appeal if you choose to appeal. So let's first of all start out with what a complaint is and how a complaint's done. A complaint, first of all, alleges that some law was violated in real estate. It needs to be legally sufficient, it needs to be in writing, and it needs to be signed by the complainant. Now, I said that it needed to be some kind of complaints on the law that was violated as it relates to real estate. Let me say this, the Florida Real Estate Commission can only discipline individuals for violation of Florida Statute 475, the real estate license law. But contained in that real estate license law is one little clause that says that the Real Estate Commission can also discipline you if you have been found guilty of another crime. Bootlegging Cuban cigars. Well, first you have to be found guilty of bootlegging Cuban cigars. Then you must notify the Florida Real Estate Commission within 30 days of that conviction. And at that point, if they decide to proceed and to discipline because of that, they can. But it takes a process to get there. So the complaint needs to be legally sufficient, it needs to be in writing, and it needs to be signed by the complainant. Now, I'm going to make a comment about a term in here. It's called the Notice of Non-Compliance. The only time that we have a notice of non-compliance is that when a broker has a routine audit, the DBPR investigators come in for a routine audit, they look around and they see a minor infraction. Maybe all the license weren't there, maybe the sign was not adequate, something minor where the public is not in harm's way. They'll typically issue a notice of non-compliance. The broker's got 15 days to fix it. As long as it's fixed in 15 days, nothing will be said. So with that, let's move on that after the complaint's filed, typically speaking, if they see that it's legally sufficient at the DBPR level, they're going to turn it over to some investigators. The investigators' jobs are to go out and gather data, to go out and gather information, to gather contracts, to talk to people, to get a feel for what took place, and then to write a report. That report is then going to be turned over to the Florida Real Estate Commission and also the Division of Real Estate. When the Florida Real Estate Commission gets it, the chairperson of the Real Estate Commission is going to appoint 2 commissioners to sit on the probable cause panel. Now, those 2 members of probable cause, one has got to be a licensee member and the other has to be a current member. And the reason I say that the one has to be a current member, right now they're drawing off of past members of FREC also to help out with these probable cause issues. Once a probable cause panel is established, they're going to be given all this information, they're going to sift through it, and they're going to say, is it reasonable that probable cause exists? Typically speaking, if the attorneys at the DBPR level, when the complaint's filed, if they find it to be legally sufficient, that means they've spotted some part of law that's been broken. And typically speaking, the probable cause panel is going to carry one step further by saying, yes, probable cause exists. Now, they may say it doesn't, but the chances are slim. Once that occurs, once probable cause is established by this panel, they're going to have a filing of a formal complaint. The attorneys at the DBPR are going to prepare this. And what this formal complaint is going to be an outline of every charge or of every 475 rule or law that has been broken. It's going to be outlined for them. The real estate licensee that's involved in it now becomes the respondent. And that person has 20 days to respond to this formal complaint. Now, the easy way to do this is say either yes, I did it, or no, I didn't. And there's a form they fill out. You just check the box, sign it, and send it in. If you don't respond in 20 days, the commission says you probably don't care. So therefore, more than likely at the next FREC meeting, that license, the licensee, is going to be revoked. Chances are, it's not set in concrete, but chances are it will be. If you say, yes, I agree with the charges, what you'll probably be confronted with is something called an informal conference. And that is to say, you're simply going to go back, have a hearing before the other members of FREC that was not on probable cause. And you'll plead your case. The state attorney's office will be there. You'll be there. Plead your case and see what will come of that. At the end of that, the Real Estate Commission will hand down a final order. Now, if you say that you don't agree with the charges, that you didn't do it, that had to be somebody else, whatever, you do have the right to a formal hearing. And that formal hearing is going to be heard before an administrative law judge. In other words, it's pulled away from the Real Estate Commission, taken to another area of the state of Florida, and the legal process. When you go before that administrative law judge, it's just like a regular trial. The administrative law judge can subpoena witnesses. They can subpoena documents. It's just like a real trial. You can have an attorney to represent you. You can have an attorney in the other, but it's probably more likely that you'll have an attorney with this. You can call on witnesses. You can have testimony. There's all kinds of things. At the end of the day, the administrative law judge is going to hand down a recommended order. When that recommended order comes down, a copy is going to be sent to the Florida Real Estate Commission, and the other copy is going to be sent to the Division of Real Estate and the attorneys. You'll also receive a copy. So here's the deal. When that recommended order comes down, if you don't like it as the respondent or the licensee, or if the Division of Real Estate doesn't like it, either party has the right to challenge it. It's called a written exception. They have the right within 10 days to file a written exception and say, wait a minute, don't like this. I'd like to have a hearing before the commission and plead my case. Once you file for a written exception, you will be heard now again before the other members of the commission that were not on probable cause. Now, if you don't file a written exception, if nobody does, if nobody challenges it, chances are the commission is simply going to follow those instructions of the recommended order and make it a final order. Now, once that final order comes down, I think it's important to note it does not take effect for 30 days. In this whole entire process, you're allowed to continue to practice real estate until it's over with. That includes the 30 days after the final order occurs. The only exception, if the Florida Real Estate Commission or the Division of Real Estate attorneys believe that you could be of danger to the public, they can ask a judge to issue a summary suspension. Now, that summary suspension will put you out of business until the hearing process is over. That doesn't happen a lot, but it could happen. So you could be put out of business, but chances are you can continue to practice real estate until it's over. Now, during the 30-day time period after the final order comes down, if you want to appeal this to the District Court of Appeal, you're more than welcome. So during that 30-day time frame, what you need to do is file the appeal with the District Court of Appeal. And if you want to stay the execution, if you want to put off that final order from becoming effective, you need to request a supersedious. Supersedious simply says we want to stay this execution until the appeal process is over. Then you can go through the appeal process. But once the appeal is over, now it's over and there's no going back to it. As far as discipline is concerned, just remember that you've got 2 or 3 things that we're looking at. First of all, the Florida Real Estate Commission, and as I mentioned, the Florida Real Estate Commission can only discipline licensees. The Florida Real Estate Commission cannot discipline unlicensed individuals. That's why the unlicensed practice of real estate is a felony, and only the state attorney's office can discipline. What can the Real Estate Commission do? They can deny your application. They can refuse to renew your application. They can suspend your license up to 10 years. They also have the ability to revoke your license. Revocation is permanent. Now, we'll say this, that once your license has been revoked, after 5 years, you can reapply for a license, but you're going to have to explain this revocation. So your odds are real slim with that. They can issue citations. Remember, the Real Estate Commission can fine you up to $5,000 per charge. They can place you on probation. As far as judicial remedies are concerned, the state attorney's office can also prosecute if they feel like it. Typically, they don't. These are misdemeanors, typically misdemeanors of the second degree. The second degree misdemeanor carries a penalty of up to 60 days in jail and or up to a $500 fine. Again, the way the state sees it, if the Real Estate Commission disciplines you, that should be sufficient. There are some things, however, that are first degree misdemeanors, and that carries a penalty of up to at least 1 year in a county jail and or up to a $1,000 fine. Violation of rental information laws is one of a few of those misdemeanors of the first degree. Also, false and misleading advertisement is a first degree misdemeanor. In addition to those two, the Department of Business and Professional Regulation can also fine you up to $5,000 per charge. And I also want you to be mindful that if you have defrauded somebody and they've lost money, there's a very good chance that they can sue you as well. So you may have a lawsuit coming at you as well. And with that said, let me make a comment about the Florida Real Estate Recovery Fund. Anytime that a licensee engages in a real estate practice and defrauds the public in such a manner that they lose money, or that person is financially damaged by that licensee, there are some recourses that person can take. One is that they first have to go to court and get a judgment. Once that judgment is established, there's a couple things that have to take place. That individual has to first of all do an asset search to show that the licensee personally does not have assets to pay for whatever that judgment is. If the licensee does have personal assets to pay for it, they've got to look there first. Secondly, they've also got to show proof that judgment has not already been settled. If they can show these things, an individual can collect up to $50,000 per single judgment from the recovery fund. Now, the recovery fund is set up to pay out a maximum of $150,000 in any multiple judgments that might have been created out there. The important issue here is that as a licensee, if any money is taken out of the recovery fund to pay for a judgment against you because of what we talked about, your license is going to be automatically suspended indefinitely until that money is repaid. So if you defrauded somebody and they've suffered a financial loss, money comes out of the recovery fund, your license will be suspended for indefinite until that money is repaid plus interest. Now, there's one exception. If a real estate broker follows a lawful order of the Real Estate Commission, for instance, an escrow disbursement order, a broker asks the commission to give them guidance on where to disperse certain deposits. The commission says give it to the buyer, for an example. The seller takes it to court and gets a court to overturn it. Well, the broker has already spent it. It's already gone. And that broker followed a lawful order. That seller over here that just got the new award through a judgment can now go to the recovery fund and get their deposit, or whatever that money was, up to $50,000. The good news is, because the broker followed a lawful order of the commission, there's no repercussions. In other words, they will not lose their license. In collecting the payments from the recovery fund, anytime the recovery fund gets down below $500,000, they're going to collect it from either renewal fees or from application fees. For sales associates, it's $1.50 every year, or $3 every 2 years. For brokers, it'll be $3.50 every year, or $7 every 2 years. And it comes along again with either your application or with your renewal. And that's all we have for Chapter 20, License Law Violations, Penalties, and Procedures. But I got to tell you, this chapter is absolutely critical that you know all of it. Immerse yourself in it at some point, learn it. I'm going to go over the important parts of it now as a good review. To begin with, a complaint must be legally sufficient. The investigation is a gathering of facts. The chairperson of the Florida Real Estate Commission will appoint 2 members to set on probable cause. The formal complaint is an outline of all the legal charges with a 20-day period to respond. A hearing can be either formal or informal. The recommended order by an administrative law judge can be challenged with a 10-day written exception. The final order handed down by the Florida Real Estate Commission does not take effect for 30 days, and during that 30-day time period, you can file an appeal with the District Court of Appeal. The notice of noncompliance is for a minor infraction, and as long as it's rectified within 15 days, nothing will be said. The Florida Real Estate Commission can suspend a license up to 10 years. They can fine up to $5,000 per charge, and they can revoke a license. The state attorney can fine and/or incarcerate. A first-degree misdemeanor carries a penalty of up to a $1,000 fine and/or up to 1 year in jail. A second-degree misdemeanor carries a fine of up to $500 and up to 60 days in a county jail. The recovery fund only pays compensatory damage and not punitive. And let me explain the difference. Compensatory is actual damage. Punitive is punishment. The recovery fund will pay up to $50,000 for single judgments and a maximum of $150,000 for multiple judgments. The license of the licensee is automatically suspended until the money is repaid plus interest, and the only exception is that if a broker follows an escrow disbursement order by FREC. And this is the end of this chapter's review.